morning, Your Honors. My name is Andy, and together with my teammates Natalie and Megan, we will be addressing Unit 3.
Okay. The preamble's statement that the primary purpose of the Constitution was to form a more perfect union offers a way to find answers to perennial and perennially troubling questions. What were the perennially troubling questions that the 13th, 14th, and 15th Amendments addressed? In what ways, if any, have the 13th, 14th, and 15th Amendments contributed to a more perfect union? And all three amendments gave Congress the power to enforce them by appropriate legislation. How and why has that power been significant?
The perennially troubling questions of the 13th, 14th, and 15th Amendments address slavery and civil rights, as well as the former Confederacy in relation to its re-entry into the Union. An overall theme, a new level of equality, was suggested by these amendments. Slavery had been a colossal elephant in the room from the writing of the Constitution up through the Civil War, where the issue finally split the country. With the Union's victory, the 13th Amendment banned slavery and indentured servants except in the case of punishment for a crime. The 13th Amendment effectively overturned the Dred Scott case that slaves were merely property. The 14th Amendment gave these now freed slaves citizenship, and with that provided them with further equality as U.S. citizens through the 14th Amendment's guarantee of equal protection and due process of law. A preeminent example of this equality is found in the Supreme Court's decision in Brown v. Board of Education. An example of equality provided by due process can be seen in the Court's decision in the Miranda case, holding that the Fifth Amendment right against self-incrimination applies to the states. The 15th Amendment guaranteed voting rights to citizens regardless of their race or religion.
The 13th, 14th, and 15th Amendments all contributed to the formation of a more perfect union by granting more rights to a larger scope of people. The 13th Amendment freed all slaves, which meant that no one was allowed to force another human being to work without pay. This amendment was not enough to protect the rights of freed slaves, so the 14th Amendment was created. The 14th Amendment declared that all people, born or naturalized in the United States, are citizens, and also prohibited states from denying anyone their rights based on their race, color, or former status as slaves. This amendment not only added the word equal to the Constitution for the first time, but also prevented the deprivation of life, liberty, or property without due process of law. By making African American citizens, the 14th Amendment increased the amount of representatives that certain states had and allowed for the first African American representatives in Congress. Lastly, the 14th Amendment's Due Process Clause led to selective incorporation of many fundamental rights in the Bill of Rights to the states. The 15th Amendment prohibited national and state governments from denying citizens the right to vote because of their race, color, or former status as slaves. This amendment further helped to establish equality in the Constitution by allowing for ex-slaves to practice popular sovereignty, basis of democracy.
Congress's power to enforce the 13th, 14th, and 15th Amendments with appropriate legislation is significant because state governments restricted the changes the amendments were supposed to bring. This especially applies to the 14th and 15th Amendments because African Americans' voting rights were challenged by discrimination. African Americans' rights to vote was challenged by poll taxes, literacy tests, and grandfather clauses. These policies were purposely made to put minorities at an insurmountable disadvantage. In a government based on popular sovereignty exercised through representation, these policies stifled a very important voice in the government. When Congress enforced the amendments against the challenges presented by state governments, citizens' fundamental rights were protected. The Civil Rights Act of 1964 enforced the Equal Protections Clause in the 14th Amendment, making discrimination based on race, religion, or gender in the workplace illegal. After protesters for equal voting rights were severely beaten by Alabama state troopers, Congress passed the Voting Rights Act of 1965, making it illegal for any citizen to be barred from the polling places for arbitrary reasons. It also eradicated poll taxes, grandfather clauses, and literacy tests, stating that they are unconstitutional. The significance of Congress's power to uphold these amendments with appropriate legislation is immeasurable because it protects the people's rights prescribed in the Constitution.
Thank you, Your Honor.
Time.
We will now take your questions.
Thank you. Is expansion of federal power, such as you mentioned, inconsistent with the Constitution? Explain why or why not.
Expansion of federal powers is consistent with the Constitution because the framers wanted to create an energetic government. A quality example of this going on right now is the not yet the prosecution of, but Julian Assange and WikiLeaks. It is a major development and major crime being committed across the ocean here. But we live in an age where technology and computers are increasingly becoming more prevalent in our society, and the Constitution could not have even fathomed the idea of internet. So I think by creating this energetic government, it allows us to monitor, and with the system of checks and balances, allows us to keep limited government, the idea of limited government, and keep Congress from violating people's rights, our citizens' rights and liberties.
To expand on what my colleague has said, I definitely believe that the expansion of power is within the Constitution's rights because the Constitution was created to be amended so that with the changing times, new laws could be added, and I believe that that is consistent with an increase in federal power.
I would like to add on to what my colleague has stated by mentioning that the federal power is normally expanded when state governments restrict people's fundamental rights. One example of this is the Little Rock 9 incident when the state government sent troops to prevent Little Rock 9 from attending public school. Eisenhower was able to send federal troops to protect them and bring them to school safely through the Brown versus Board of Education case.
How have the 14th Amendment's due process and equal protection clauses contributed to the principles of limited government?
The due process clause and equal protection clause have contributed to limited government because they have further restrained the ability of government officials to act arbitrarily. The due process clause states that all laws need to be applied fairly, which prevents government officials from applying certain laws to some people and not to other people, which can be a use of power arbitrarily. And the equal protection clause prevents discrimination, which prevents officials from discriminating against people for their race or color or gender, which can also be arbitrary.
It's very important to the idea that because it's an additional check on the government in itself. By having the equal protection clause and the due process clause, it assures that no citizens' rights or no citizens' beliefs or intentions are violated by government, and I think that's a very, very solid and important idea confirmed in the Constitution.
A follow-up that's a little variant on just the last question. How are the due process and equal protection clauses of the 14th Amendment related to the principle of rule of law that we discussed when we were doing the answer to Unit 1?
Rule of law states that no one is above the law, essentially. And by having equal protection and due process, it assures that no person in government can be outside of the law, and everyone has equal protection, and no one's rights and liberties will be violated by these clauses.
The due process clause and equal protection clause were both created to establish a greater level of equality in the United States Constitution, and a principle of rule of law is creating equality, so that's another way that they are related.
To add on to what my colleague has said, but through these clauses, rule of law is enforced because it keeps governments from acting arbitrarily against certain minority groups.
For the first time the word male was used in the Constitution, or the first time the word male was used in the Constitution was in the 14th Amendment. Why weren't women included in that amendment?
I'm going to say this in all due respect before I begin here. But when these amendments were created, again I say this in all due respect, women did not have a central role in society, in mainstream society. They did not really hold public jobs. They were more of a caretaker for the families and for children and things of that nature. So I think at that point in time, it didn't really come across their mind that, oh, women are part of society too. And then up until the civil rights movements in the 60s, when women finally gained suffrage and gained civil rights that they had, in my opinion, were long overdue.
Just to expand on what my colleague has stated, when the founders created the government, they wanted to take as much power away from the majority as possible because they didn't believe that the majority was capable of ruling the government. And a common belief when the Constitution was created was that women were slightly incompetent and unintelligent and were not capable of ruling or leading a government.
I would also like to add on to what my colleague has stated by mentioning the Seneca Falls Convention, which happened 7 years before the amendment was ratified. This was the first major event in the women's rights movement where the Declaration of Sentiments was published. Over the next century, women's rights have become a very important issue, and that at the time they were just beginning. The women's rights movement was in its infancy. Excuse me.
Please finish.
Thank you. The women's rights movement was in its infancy at the time that these amendments were ratified.
Thank you.
Thank you.
You guys did a terrific job. You know, the bar was set in the first group. You just keep, hitting it. So it's great. I particularly liked the references to WikiLeaks because it's as contemporary as you can get. And Megan, I love the fact that you backed up your opinion with the increased federal protections over states infringing individual rights with a particular instance, instead of just saying it, which you could have done. You didn't do that. You backed it up with fact, and that's always a bonus. So, good job.
Also, an excellent job. I especially like the use of examples, which Megan pointed out at the end, and also Andy pointed out with WikiLeaks. I think it's important that you're able to show the important application of these amendments to current examples and current controversies. So I like that as well. And it's pretty clear that you understand the content of this unit by going back, in the follow-up questions, by going back to examples from the unit and the content of the unit. Nice job. Thanks.
Great job. I think one thing I noticed that this group's done, and maybe you've been watching, and actually, I don't know how you can learn something new in the 40 minutes we've been sitting here, but I noticed you're a couple of times here you were restating the question within your answer. I think that's a great practice to learn, a great tactic, and it'll help you stay on point. And sometimes the question itself will give you a little bit of the answer in it, so you make sure you don't miss those clues when they come up. Natalie, I noticed you especially did that in regards to with my question this time. I noticed in Unit 1 you didn't do that, and it would have helped you. So I think that's fantastic that you can pick up on that kind of thing and improve your practice in this kind of demonstration. That's what this is for. Andy, great answer to the question regarding women's suffrage. I commend you for taking on a tough issue like that. I would caution you to be very careful about the precision of your language. You mentioned that women didn't have a large role in society at the time. I think maybe a more appropriate thing to say would be that women didn't have a large role in government at the time, because society, includes much more than government. I think that the examples you gave about the contributions that women made to sort of the home front were important, and that those are contributions to society. So.
Again, I join my colleagues in saying that job well done. You filled the time with thoughtful comments. You worked well with each other. You were poised, and everything was on point. A couple of things that I really liked is I like the references that you made to the Civil Rights Act and the Voting Rights Act in terms of bringing forward what the 14th Amendment was all about and showing the need for Congress to fight against the reluctance in some areas of the country to go forward and grant equal rights. On the issue of women's suffrage, there are a couple of things that you could have added in that may help you if you have to answer that question again. One is the fact that those who are proposing the 14th Amendment, to put it in a little bit of historical context, remember the amendments came in sequence, and the 13th Amendment was not being followed too well in the South. They came up with the black codes to try and exclude the former slaves. And those who were putting up the 14th Amendment felt that to add women's right to vote in with that would just dilute the effort to try and bring equality to the former slaves. So that's, you know, that was a substantive piece in there. And the other is that as far as the way people thought of government in those days, remember that the right to vote in a lot of areas, the thought was always dating back to colonial times that property owners were the best voters because they had a stake in what was going on in the community. I mean, that was starting to dilute as we got into the 19th century. But the thing is that with most married women at the time, their property rights were subsumed in their husband's ownership of the land. So they did not have separate property rights. So for the other reasons that you mentioned, it was viewed that, well, maybe they shouldn't be voting. So those are a couple of other points that you can bring in on it. But otherwise, I think, you know, spectacular job.
Thank you.
Thank you.